The broadcast is now starting. All attendees are in listen-only mode.
Right, good afternoon, everybody. Hopefully everybody can hear me, and I'm projecting out there. Okay, I'm getting the nod from my team that I am. Welcome to this subject access request webinar. Just a couple of admin points before we start. Just to let you know that all the attendees are muted throughout this session. However, if you have a question, you can type it in the question function, which is on the webinar control panel. And then at the end of the session, we'll allow 15 minutes there for questions that you submitted. So, and also the slides and the recording will be available to everyone, hopefully tomorrow morning. So let's crack on. Right. I'm John Potts. I'm head of DPO, DSAR and breach support, incident response management and data subject rights at GRCI Law. You can see I've got experience in the law enforcement sector and across central government, both as a data protection officer and departmental security officer. Prior to joining GRCI Law, and other former colleagues out there listening in, prior to joining GRCI Law, I was head of information law and security at the Metropolitan Police. We used to handle the odd subject access request over there. When I left the organisation in December of last year, December 2018, they were averaging about 5,500 to 6,000 requests per year. So a fair amount of subject access request experience. So who are we? I'm part of GRCI Law, which is part of the GRC International Group. So various companies within the group: Vigilant, ITG, IT Governance, ourself, GRC International, and GRC e-learning, DQM, and GDPR.UK. So what do? We are a one-stop shop, if you like, for all of your cyber risk compliance, books, anything to do with data privacy. We also provide data privacy consultancies. We do gap analysis, privacy audits, DPO as a service, breach support, everything to do with privacy on that side. We are resourced, certainly on my side, on GRCI Law, by experienced DPOs, lawyers, barristers. As I say, we're the one-stop shop for cyber risk and compliance. We've been at it. I think we're probably one of the first companies to set up in this arena, and we've certainly got the backing and the resources to deal with any problems that you might have. So please give us a shout. We're not a conventional law firm. We're not a traditional law firm, in as much as that certainly on GRCI Law, we don't deal with contentious issues, but we do deal with data privacy issues. Right, into today then. So the agenda for today, what we're going to cover: an introduction to DSARs, the challenges faced by organisations when handling DSARs, how to simplify the processing of DSARs, and then using a case study, practical steps to manage DSARs in compliance with the GDPR. Those of you that know me, and I know there are former colleagues out there, will know that I may wander off the agenda, but I will get all the points across. Okay. As I say in the beginning, life was very simple. A few subjects paid their £10 by cheque or postal order, for those that can remember it, and made a request via a good old-fashioned letter. And along came GDPR, and with GDPR came social media, and all of a sudden things changed. We started to see applications coming in from a variety of media, and applications, as we know, can be made verbally or in writing. I think it's fair to say that the day after GDPR came in, the 25th of May 2018, the very next day, the Met Police received 2 subject access requests via their Twitter account, but more on that later. We've also seen this shift, and again, the statistics will show later, where we're seeing more requests from disgruntled employees, members of staff, as part of employment issues, employment tribunals, etc. And because we're seeing more of that, we're also seeing more third-party applications. We're seeing applications from solicitors or via solicitors. So these are all things that we've got to be aware of when we're looking at DSARs. Some things have not changed though. The right of access, whether it's Article 15 or the old Section 7, the right of access allows data subjects to their personal data. Confirmation that their personal data is being processed, and confirmation of how and why their personal data is being processed and the lawful reasons for that processing. That's not changed. It's about their personal data. And the thing to remember here is that it's a right of access to the personal data, not to the document that personal data is contained within. And that's, again, that can be quite disjointing for some people, or disconcerting for some people, where they think they've got to provide the whole document. Okay, a couple of other small pieces here. Not real changes. As the ICO has said on numerous occasions, subject access requests have been with us since 1998. It's nothing new. We shouldn't be panicking about learning GDPR and how to deal with them, because, as I say, they've been around for a long time. But the information must be provided within 1 month of receipt of the request. And as we'll see in the case study later on, you get it today on the 5th, then the response is due by the 5th of the next month. You can refuse a request where they're manifestly unfounded or excessive or particularly repetitive. But remember that the burden of demonstrating the correctness of your decision rests with the controller. Manifestly unfounded, several areas where this might come in. If it's just because it's a lot of data doesn't mean that it is manifestly unfounded. So, but if a subject makes a request but offers to withdraw it, if you reinstate them, and that's actually a request that we've seen, a subject put a massive request in and then said, however, if I'm going to be reinstated, I'll withdraw the request. That's obviously manifestly unfounded. So, and also we've got this verification of the data subject identity, proportionate. We've got to make sure that that is proportionate. But again, we'll go into that later in the case study. So, failing to comply with the DSAR. These are the latest figures available from the ICO. 46% of all the complaints that they receive are about DSARs and about the timeliness and about how they've been responded to, whether they have been responded to correctly, whether information has been withheld, etc. So it is a growth industry on both sides, whether it's us for dealing with them or whether it's for the ICO for dealing with the complaints. So what are the challenges associated with dealing with DSARs? I think in whatever industry or organization you're in, we're all aware that we're gathering far more data than we used to. Are we gathering it properly? Are we holding it properly? That's where your DPO would come in and tell you there, hopefully. But we're gathering it. There's the subjective nature of many of disclosure exemptions. I've had many discussions with lawyers, legal services about whether an exemption is valid, whether it should be used. I've had lots of discussions quite recently with a certain director within quite a big organization who said that a particular email shouldn't go out because it was his personal opinion. of the person that had made the subject access request, and now in the cold light of day, she found it quite embarrassing that what she'd said. Well, it's that old adage, if you don't want to see it in print, don't write it down. But they had, it was in the email, and I'm afraid it went out. DSAR is an expensive, time-consuming, and hard work. I have a whole team that deal with DSARs, and even though that's what they do all day, they are still a time-consuming issue. They take time within an organizations. Organizations aren't prepared. It's still, despite the fact that we've had it since 1998, people are not prepared for accepting DSARs. And as I say, this shift that we've seen from the client or the customer now towards the internal DSAR is causing even more problems. Again, those of you who know me will know that I'm not making this up. I spoke to somebody only 3 weeks ago who told me that they didn't think that GDPR applied to internal staff, so they couldn't do DSARs. It was only for customers. Organizations lack an effective process. There's no doubt about it that process is the key to this. If you've got everything in order, then DSARs are so much easier to deal with. Employers very often have difficulty identifying when something might be a DSAR. Remember that a DSAR doesn't have to say that's what it is. It doesn't have to say, in accordance with Article 15, I want this, that, and the other. It doesn't have to be on a specific form. Again, we know the ICO advises that if you can put a form out and to make life easier, then that's great. But the applicant doesn't have to use that form. So people need to know, your team, your staff need to know when a DSAR has been submitted. And that might be embedded in the middle of a letter. Right in the middle of a complaint letter, there may be the one line, and I would like to see a copy of all the information that you are holding on me. So do your customer services people know how to identify a subject access request? Does the school secretary or the receptionist know how to identify a subject access request? Somebody comes into the reception of the school, the receptionist greets them. Hello, Mr. Smith, how are you? I'm great, thank you. How's little Tommy? Tommy's fine. Can I see Tommy's file? Everybody needs to know how to recognize a DSAR, and that builds into the lack of effective employee training. If you've not got that right, then you're starting at a disadvantage already. So the further challenges of dealing with a DSAR. This is a survey that was carried out last year, and it backs up the numbers that I was saying. That increase in the number of employee DSARs since May 2018. I don't think the reduction or the removal of the £10 fee has hinted on this at all, has impacted on this at all. Again, within the Met, we actually refused we withdrew the £10 fee about 2 years prior to the introduction of GDPR, and we saw no discernible rise. I think this is people becoming more aware and actually using the DSAR process as part of the employment regulations, whether it's for a tribunal or whatever. As you can see, the increase in cost associated with responding to DSARs, 83% have had to put in place new guidelines and procedures, and 27 have appointed additional staff to deal with an increased DSAR request. 20% have adopted new software or technology. I think that's because a lot of people have found out that they're just holding stuff for far too long and leaving themselves open to it. So how can we simplify the DSAR process? Some considerations here. Look at the nature of the data that you're processing. Consider whether it's particularly sensitive or contains third-party information. Do you need to be doing that? If you don't need to be doing that, then you shouldn't be doing it anyway, but these are considerations that perhaps bounce off of the DSAR. Look at the purpose of the processing. Is it likely to cause detriment to the individual? Again, if you don't need to process it, don't. How often is the data altered? If the information is unlikely to change between requests, you may decide that you're not obliged to respond to the same request twice. Everything is down to you making that decision, seeking advice as to whether you're going to do that. I consider that there are two types of, in the main, two types of data subject access request. There's a simple request. And the simple request, everything's in a single location. There's no third parties included in the data, but you still might want to involve the DPO to validate the disclosure. So this is something like, dear sir, could I please have a copy of the agreement that I sent to you 6 months ago? No problems at all. You can pull it out, you can send it off to the applicant. That's it, job done. If, of course, there's a simple subject access request, there must be a complex one as well. And I would define a complex one as multiple information sources. And again, we'll see in the case study that I'll show you. This can be HR, it can be personnel files, it can be grievance files, it can be emails, it can be WhatsApp messages, it can be all sorts of things. It could be that it's the release of contentious information that perhaps impacts on other people. There's perhaps management forecast information. You might have several requests from the same individual, not that constitute any other thing other than they decided that one day they wanted this, the next day they wanted that. Involves the release of third-party information. We'll discuss third-party information later, but bearing in mind that it's not just a case of redacting everybody's name other than the applicant. If you do get a complex DSAR, then you should certainly seek advice from your DPO or your legal advisor if they are not already part and parcel of the process. Okay, so third-party data. If you are going to include third-party data in there, then unless it's really apparent that the person is happy with it, then you must look at the duty of confidentiality of that third party. And that might not just be that there's somebody working in the office. It could well be that there's a whistle policy to look at, a whistleblowing policy to look at. You've got to look at, if you can contact that third party, what steps have you taken to seek their consent? Are they willing to give consent? Are they capable of giving consent to that information being out there? And remember that just because they say they don't want that data to go out, their details to go out, that's not an exemption. There may be other exemptions attached, but bear that in mind. So when you're dealing with third parties, don't automatically say, look, I'm going to take your name out of this because it's not their personal data, because it may well form part of that personal data. And again, contact your DPO or your legal advisor to see what can and can't be disclosed or withheld, i.e. redacted. And again, I'll put this point all the way through, but the data subject should be informed why you've withheld data and the rationale behind it. So the key stages of the DSAR as I see them. Let's fill these in. Step one, recognize it as a DSAR. Is this a proper data subject access request, or is it somebody asking for corporate data? And if you're a public authority, is it a Freedom of Information Act request? So recognize what it is. Is this a subject access request? Validate the request, proof of identity. Keep it proportionate. And I've put that in there because I've recently dealt with a company, and the company involved, quite rightly, sought quite a high level of proof of identity before they released the information. The ITO came back and said, why are you asking for this level of information? And they were able to justify it. But the ICO is certainly looking at the moment at keeping the proof of identity proportionate. If you are an organization that accepts an email address as being proof of identity, and some of the organizations that we deal with, they actually do that in the course of their business. Then you can't then say to somebody, right, I now want a copy of your passport with your driving license, a utility bill within the last 6 months, and your thumbprint before I release that data. So keep it proportionate. Handling requests on behalf of third parties and children. As I say, we're certainly seeing more requests now coming in through solicitors. Most solicitors' offices now that are dealing with employment issues or any other kind of dispute where there's the start of it is a subject access request should already be on board and let you know by proof of identity that they are acting on behalf of the data subject and for that identity for you. But bear in mind that the decision to release rests with yourself as data controllers, and be very wary of just sending information out because it's on headed paper and it looks like a valid solicitor's address. If you're not happy, then wait to get that proof of identity before you release it, because otherwise you're going to maybe looking at a breach yourself. So you've not only answered the DSAR incorrectly, but you've breached personal data as well. Personal data involving children, always a contentious issue, but we have lots of schools and academies on that we have as clients. If you do have a request made on behalf of a child or even by a child, because there's nothing to say children, as we know, can't submit subject access request, then this is definitely an area which you need to discuss with your DPO or your legal op department if they're involved in such matters. Step 4, the redaction. Remove the third-party data if appropriate, and we've already, I've already harped on about removing third-party data, and remove any other data that might be exempt from disclosure. And remember, it's the personal data that the person's entitled to, their personal data, not the document itself that might be in there. And the third thing, what I will say is maintain a record of everything that you're doing. Make sure that if this subject access request does go any further, if it does go to the ICO, if it goes beyond the ICO, then one of the things that the ICO will ask for will always be, show me your timeline, show me when you got this, how you dealt with it, what you did, etc. So very quickly, some practical steps to manage the compliance. Make sure you've got effective data governance practices. This all boils back to your Article 30 record, your record of processing. Make sure you've got these practices and processes in there. Make sure you've got policies and procedures for handling subject access requests. Have a clear record of the data held so you know where it is. Again, your Article 30, your ROPA. Evaluate the data. All these are contained within the principles. Do you need to hold that data? Is it accurate? Is it up to date? Reduce the amount of personal data you're holding. Again, we'll see on the case study, the applicant there wanted data from 2011. You have to wonder why the company was holding emails back to 2011. Make sure you erase data in line with your retention policy. If you don't need it, don't hold it. Train staff to be able to identify DSARs. Again, I'm sure we've all seen, those that are involved with DSARs have seen the email that came in, somebody looked at it, oops, don't know what that is, filed it away, and it wasn't until the second or third one went to the director or the headmaster that somebody realised that there was a DSAR actually in there, and the clock had been ticking for a long time. Ensure staff understand what their roles are when handling DSARs. As an aside here, once you get the DSAR, then it's all the information is in play, as we know. Going back to the director that I spoke about, they didn't, I hasten to add quickly, but once they've got the DSAR, one of the things they wanted to do was to go through and erase all of the, and delete all of contentious emails or all the ones that they thought were personally incriminating, in as much as what they said about the applicant. So Make sure your staff understand what it is about a DSAR and how they handle it. Create a template response. This is not I'm not saying use a blanket exemption, far from it. What I'm saying is to make sure, or if you've got if you deal with a lot of DSARs, make sure you've got a template in place so that you fill each section in when you've dealt with that particular part of the subject access request. So keep that template, keep your DPO informed. Nothing a DPO hates more than to be told that we had a DSAR in, and I think it was due to go on yesterday, but we've not done anything on it. So keep your DPO informed. Keep a central log of all your DSARs. Okay, record the timeline and details. This, as I say, I've seen so many times. I've been in several court cases on subject access request, several hearings, discussions with the ICO, call them what you will. And it's so important that you maintain a centralized records of your DSARs, when it was received, details of the request, that you've confirmed the identification, when you fulfilled it, and any issues or concerns that you had around the DSAR itself. So, as I say, these are important to think beyond the DSAR. Fulfilling the subject access request or the DSAR is only part of the issue. You should be looking at, if this is an employment tribunal, or we think this is part of an employment tribunal, then what will be the next stage? The next stage, if we've got a disgruntled employee and we've sent off the subject access request, the next stage is that applicant is going to apply to the Information Commissioner and complain that it's not been fulfilled properly. This timeline, this record, will help you to answer the ICO's questions properly. Okay, into the case study. So this is an actual subject access request case study that we dealt with. So for this case study, you are the director for a medium-sized retail outlet and you receive a request from a former employee via a solicitor requesting all emails between all members of staff that mention her by name, initials or pay number since she joined the company in 2001. And just adding to that, in her request, she did say, sometimes I'm known by the letter C. People call me C. Sometimes they call me CB. So I want the search to include C, CB, my name. As you can imagine, try to do a word search and put the letter C in. Yeah, it was a big old task. She wanted a copy of her personnel file. She wanted a copy of all emails, social media, files, notes, memos or recordings that mention her dismissal or her grievance. A copy of her grievance file and a copy of her HR file. And she put that in because she was under the impression that management kept a separate personnel file away from HR. They didn't, by the way, but she was under the impression that they were. The thing to bear in mind there is that sometimes when people submit subject access requests, if they are disgruntled employees, they are looking for what you release, but they're also looking for what you might not release if they know something is there and you don't release it. Or if they've got a friend still within the organization who says, you want to put a subject access request in and ask for all the emails between A and B, because I saw one a couple of weeks ago that wasn't very complimentary to you. So they were looking for that particular email that was in there. Okay, continuing, the request is dated today. So we've got a month from today to complete it. The applicant was recently dismissed for overcharging customers at the point of sale. And you're aware that she'd already started proceedings for wrongful dismissal. You're already dealing with your own legal counsel regarding the impending employment tribunal, and her grievance was not upheld. So that's the subject access request, and that's what you know about it. So what are your considerations? Is it a valid request? Yep, it's information about her personal information. It's a request for her personal information, so not a problem there. Identity verified? Yep, because she sent it from the email address that you've got on file within HR that you've used to communicate with her in the past. You can, of course, obtain further identification if you're not happy, but if you've already been using that email address to discuss other matters related to her dismissal, grievance, etc., I suggest it would be a bit churlish to want any more. But if you're not happy, verify that. Is she fishing to obtain information from an employment tribunal? You bet she is. That's exactly what she's doing. Does it make any difference? No. Several cases, certainly that I've been a party to and I'm aware of, regarding abuse of process, and there have been rulings that have been overruled, and there are several cases going through at the moment as to when the original subject access request was put into Section 7 of the 98 Act. I think what their lordships envisaged was that it would be used to let people know if data was being held incorrectly about them, or if there's no lawful reason for processing. That's gone now. I think successive cases have proved that. And so I've certainly been to court twice and tried on the abusive process, but each time the judge has found in our favour on a different matter and not ventured to go anywhere near the abusive process. But there are cases in train at the moment. Dharma and Dharma is one, certainly, that is going through. Is it excessive? It may well be seen to be excessive. It may be excessive because you've made it excessive. You can, of course, go back and ask that the applicant narrows down the search so you can to help with your search. But the ISO has recently stated that you cannot stop answering the request while you ask for a redefinition of time. So nothing should stand in the way of you getting that information together. Note when it's got to be completed by. So that's the date you've got to work back from. So that's your considerations. What are your immediate actions? Log the request and start the timeline. I really can't emphasize enough how important that is. Consider putting a hold on the deletion of files, CCTV. The request may well be, I want to see the CCTV that shows me going to work on these days. Now, if you've got a 30-day retention policy on your CCTV, and you receive this on day 20, that's plenty of time for you to put a hold on that. And the same with files. Stop them being deleted, stop people deleting them. Start the searches. The way that we, certainly the shift now in emails, Office 365 and similar software and what have you, make it easier to search for specific emails between specific people. But it could well be that you actually start the search by saying, okay, dear A, we've had a request from B. Can you please make sure, or can you please copy all emails that you have that talk about her, that's her personal data? That may well be what you've got to do. Acknowledge the request. Tell the applicant that you've received the request and that you're going to deal with it, and that you will deal with it by the date shown. Contact HR, read grievance and the HR files, and identify third-party data as you're moving along. Because this is an employment tribunal, there was lots of things involved in this particular case, including, as I said, the whistleblowing policy, and also there's the involvement of ACAS. Now, legal professional privilege doesn't necessarily cover ACAS documentation, but ACAS have their own legal framework that they have to work under. So there are lots of things to consider in this case file, which is why I've used this one, because, as I say, there are lots of issues that go in there. So the additional actions. The initial search on this one revealed 70,000 plus documents. And initially there was something like 50,000 emails, but then obviously there was the attachments that went for that. Again, I've highlighted excessive. Could well be. You're going to have a look at that and see exactly why it's excessive. So we were able to narrow it down, and we didn't just go for the C and CB as she was known by, but we did do that. As I say, consider asking the applicant to narrow down the request, but we've already discussed the pitfalls of that. Consider extending the response period, which is what we did in this particular case. But remember, it must be done within the first month. You cannot leave it until 2 weeks into the second month and think, oh gosh, we're not going to get this done. You must do it within the first month. The same as any other piece that you use. If you're going to use excessive, you're not going to answer it, or whatever, you must do that within the first month. Software to deduplicate. I spoke to a similar company to our own not so long back, and they were saying that they dealt with a request that had 1 million documents in it. And this is what I said about where you've got an email chain, and it's only the last one that you really need. So from that 1 million documents, they were able to bring it down to 12,000 once they'd deduplicated, as they call it. I'm not actually sure that's a word, but deduplicate was what they used. Then you've got to manually review the third-party data and everything else that you've got in there. Apply the exemptions and notate all the redactions and the exemptions that you use. And the reason I say that is that when the inevitable ICO complaint comes in, the ICO will say, or might say, hi there, thank you for that. We noted that this is the information that you released to the client. We're looking at page 995, paragraph 7, line 5. Why is that being redacted? When my team do redactions, every single line is annotated with the exemption that we've used, why we've used it. So you've got that in there, and you don't have to go back to the ICO, look at your unredacted copy, then almost conduct the review all over again. Check with legal for the use of legal privilege. If you've used legal privilege, make sure that you've used it in the right context. Check with legal. Check with the company that you've used. Check with your in-house counsel that they are happy that you are using legal privilege in the right manner, because it's one of those things that just because there's a lawyer in the room doesn't mean the conversation is legally privileged. So make sure you're happy with that exemption. And just because you're a law firm doesn't mean that you can use LPP. Okay, drawing it all together then. Once you've done the DSAR, check and check again that you've completed the request. And what I say to my team is, look at it from the point of view of the requester. Imagine that you are the requester. What is it? Have you answered that question to your own, what you wanted? Have a look at it. And if you haven't, then you need to look at it again. Explain any exemptions that you've used within the covering letter. It could well be that everything is third party. So you can say, where there are exemptions used, they are all under third party. But if they're not, then you may have to explain or certainly give a list of the other exemptions used. Provide secure access. Again, it's so easy to complete the DSAR, put it in an envelope, put it in the post, send it out, breathe a sigh of relief, and then 4 days later, the applicant comes back and says, still not got my DSAR. And you say, but we sent it out. Still not got it. And then you've got a breach. So we're right back then. So look at the secure access. Setting up something like egress to move secure files around is cost effective. find a secure space. When we move files around, whether it's from the applicant or whether it's from our client, we use secure share file. So make sure you've got that in place. Prepare the files for the ICO complaint that's coming your way. Make sure you've got a copy of the request on your timeline. You've got a copy of all the information that you prepared, that you got back from everybody. Make sure that you've got a redacted copy to show the difference. Because if you're fighting an employment tribunal for a disgruntled employee, then the last thing you want to be doing is fighting on two fronts whilst you fight the ICO, because you have the opportunity of completing a DSAR and for some reason or whatever you've messed it up and you can't say why you've done it. So don't be caught out fighting on those two fronts. Okay, there is help at hand. How can GRCI law help you with your DSARs? We provide, and one of the teams I head up, provide a service called Privacy as a Service. Now, Privacy as a Service really fell out of our client needs. We used to provide DPO as a service, and we still do provide DPO as a standalone service. If you need a DPO, we can act for you. But what Privacy as a Service does, it gives you access to your own DPO, because we will be your DPO. It gives you our breach management service. So if you have the inevitable breach at 4:45 on a Friday afternoon, then invariably I'm still sat here, or one of my team is, and will advise you whether it is an actual breach, whether you need to report it, whether there are other implications. If you are part of the NIS regulations, do you have to report it there? If you're a health service provider, do you need to report it to the Care Quality Commission? So we'll advise on that. If you do have to report it, we'll help you put the form together to make sure that you give the ICO enough information to act upon without opening yourself up to further investigation. So we can look at that. So that's what the breach management service does. You obviously get DSAR as a service. Now the DSAR as a service, I'll come back to on my next slide, but we do data privacy manager for organizations that need an experienced professional to help manage the data protection and data privacy compliance program. That's linked really with the DPO support service, where you've got a less experienced in-house DPO. Well, this gives them the support of having somebody to call on. And it's not just somebody, because we provide you with a DPO and then we provide you with a second. So if the DPO is not about, you've got access to that DPO's second, which means, of course, that our DPOs are never on leave. Okay, we're not here at Christmas and bank holidays, but in the summer holidays and things like that, then you've got a DPO and a second. And we also provide EU representative services. Now, obviously, as we're in this period of transition and we don't know where we're going to be with adequacy, but that's something worth bearing in mind, that we can provide representative services within the EU once Brexit is complete. And contract and legal, as I said right at the very beginning, we don't deal with contentious legal issues, but your contract and legal service as part of this package, then we provide DPIA support, policy support. We will look at your contracts to make sure they're GDPR and DPA 18 compliant. So it's a complete data privacy package. And as I say, on the DSAR as a service, probably the easiest way of summarizing this slide is to say that what we do is, if you've got a one-off complex DSAR, like the case study that we've done, which was, as I say, a company that had never had a DSAR before, then we dealt with that, if you will, from cradle to grave. And if you are a company that experiences lots of DSARs, again, the service, all we need is a single point of contact within your organization to help us get the information out. Once we've got it, then we've got the software, we've got the expertise, so you can get on with running your business, and we can take the hassle out of subject access requests using the experience and the expertise that we've got to make sure that they are answered correctly, timely, and we will liaise with the Information Commissioner or any other authority that we need to assist you with that. I'm sure you'd be pleased to hear that there's a free guide to DSARs that you can download. And as I say, tomorrow this will be this presentation will be out there, so you can, if you really can't sleep, you can listen to me all over again as I go through it. Okay. Any questions? Okay, I've got a couple of questions that have come up. Bear with me while I read them, and I'm going blind here, folks, so make sure I can answer them. Okay, the first one is, we're an educational establishment. What happens if we receive a request from a parent and there are safeguarding issues? This goes back to handling requests relating to children again. Actually dealt with this kind of request, and without a doubt, what you need to do is to contact the safeguarding officer within the school. Every school has got one. They go by various titles, but everyone will have a safeguarding officer, and you need to make sure that you're not releasing information that may be detrimental to the child just because it's from the parent. Seek advice is my response to that, either from your DPO in the first instance, and then let your DPO contact the safeguarding officer. Okay, this is obviously from a school. I suspect the same questioner. Do we need to cover school holidays for subject access request? Short answer is yes. The clock is ticking. From the minute that request comes in, the clock is ticking, so you need to have it covered. You need to make sure that somebody is covering your email address where the requests are going into. So on your privacy notice, you should say, in the event of you wishing to submit a subject access request, use this email and make sure you monitor that email. If you're using Twitter, Facebook or anything else like that, during the school holidays, make sure that's monitored so that they can pick up. Nothing worse than coming back after the summer holidays, 6 weeks, 7 weeks, whatever they are nowadays, and finding out that you've got a whole batch of DSARs that are way overdue. So yes, definitely. Okay, the next question. Let's have a look, sorry. Some of the data that's been requested is buried within a large spreadsheet. Do I have to redact all the other data? Well, goes back to right at the very beginning when I said that people are entitled to their own data. Doesn't mean they have to have an entitlement to the document. So what you can do in a situation like that, perhaps, is to cut and paste the relevant section. Don't change, obviously don't change the data that you're releasing, but cut and paste that into a separate document. It may be as easy to redact the whole document, but then you're sending out perhaps pages and pages of redacted, blacked out information. Just a word of caution there: if you are doing your own DSARs, then be very, very careful if you are operating in Word or Excel, because if you simply black out the data and think that's a redaction, there is a way, if you send it electronically, where the person on the other end can undo that redaction. So be very, very cautious of how you're doing that. But yep, in answer to your question, what I would suggest is cut and pasting the relevant information into a separate document. And the next question, we use WhatsApp. Is that included in a DSAR? Yes, most definitely. Brings us back to what I was saying about the basic principles of data protection. WhatsApp is a really, really good piece of software, piece of good social media, call it what you will. End-to-end encryption, really good. And lots of companies use it for moving information around. What I would say to you is, and this is again in the light of an actual case, what I would say is that if you use WhatsApp for discussing personal data, then as soon as you get back to an office environment, that data should be stored in the proper format, whether it's in the personnel file or whatever. It needs storing in there. Once it's stored there, then delete it from WhatsApp. So therefore, you've only got one source. Because again, go back to the applicant that I was talking about. They knew exactly what they're asking for when they wanted social media. They wanted those WhatsApps. They knew because people had said, there's something in the group about you, you need to get that. So that's what they were looking for. And that's the fighting on two fronts again, fighting the employment tribunal and fighting the DSAR. So WhatsApp, really, really good. Get it onto a proper file, then delete the WhatsApp and make sure that is in your policy. Otherwise, it's WhatsApp, have to be screenshotted and then produced and redacted and everything else that's in there. So that's what you've got. Okay, I have no more questions in there. If you do think of any questions, then please, I think you can still submit them, or if not, submit them to my email. I don't have my emails on there, but it's john.potts@grcilaw.com, and we'll get those answered for you. Other than that, I think I can all give you 10 minutes of your time back. I'm just looking, no further questions. That's great. Can I thank everybody for being here? Thank you for your time. I hope it's been informative, and I look forward to seeing you all as clients, those of you who are not already clients, and thanks again to all my colleagues that are out there. Thank you.